Stop.
I said I won't say anything else.
Stop.
Good morning.
Gil Stanford.
All right. Ms. Norman, can you state your name?
Susie Norman.
Okay. And that's a wrong screen. No, it's okay. I'm good. I'm good. All right. Where are we on this case, folks?
At the last hearing, we were reading on the evidences I sent. One was a flash drive.
Yes.
Due to the weather and the courts being closed, it hadn't been logged yet.
Correct. I think we have it now.
Yes. And I believe that your coordinator helped Mr. Stanford to play his flash drive.
Right. Did you get all the stuff off of the flash drive, Mr.?
I did see the video of the previous hearing on that, yes.
Okay. And so with reference to that previous hearing.
All right. So right away, we're seeing a classic courtroom delay problem. Evidence exists, but it hasn't been properly logged into the court system yet. And in court, if it's not officially entered, it basically doesn't exist. That flash drive might as well be a USB from the Stone Age until the clerk stamps it in. And notice the judge's tone. He's calm, but he's already trying to steer this case away from chaos.
You have something you're holding up. What are you trying to do?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15, 2024 hearing? That's what you, okay.
That's right.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say
how did you send this to Ms. Norman?
U.S. mail.
Okay, well.
Yeah,
This is the judge speaking pure courtroom reality right here. He's basically saying, I can't rule on something if only one side has it. That's due process 101. Because if one party submits documents and the other party never receives them, that's ground for appeals reversals and the kind of legal mess judges hate more than traffic court on a Monday morning. This isn't about favoritism. It's about fairness and procedure.
That's going to be.
I thought our hearing was a little later in the month. I thought she was going to get it. And I just got the notice about our hearing date yesterday. So I was thinking maybe I should.
Well, that maybe should tell you something about the mail. All right. Here's what I'm going to do. I think we have Ms. Norman's email, right?
Yes, sir.
Okay. So, folks, they're not sure that. Yes,
Can I say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point, it's, we're just on the court's time and we're wasting it with,
well,
all of these things.
Ms. Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. All right, because I don't want to end up in this circumstance. We have Ms. Norman's email?
Yes, sir.
All right. So what I'm going to do to expedite the process, Ms. Norman, because normally I put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay?
So,
And then
so what
my
happens
next-
then? He's got an answer to the video, and then I see something on his answer, but yet I can't
then
answer.
you guys can argue that before me. Ms. Norman, I can't force this to go any different.
I don't
If
want
I
to argue.
could,
I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
so I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to
I'm not a
proceed
failure.
with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Ms. Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case. He is.
Norman, I'm
I'm
going to
just-
tell you this, and then I'm not hearing anything else from you. I'm going to do what I got to do.
That's fine.
I'm just
that's
going to,
fine.
no, do not talk. Stop.
I said I won't say anything else.
Stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep. We'll just put it out so she can get the mail. I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to
Don't
happen
treat
that
me
way.
rudely.
Give
I'm
me a
very
date. I'm
respectful.
done. Mute her because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
Thank you, Aaron. See that?
Yep.
And boom, this is where the hearing completely derails. The judge gave her a shortcut. Email delivery instead of waiting on slow mail. But the second the judge feels disrespected, that offer disappears instantly. This is a huge courtroom lesson. Judges have wide discretion over scheduling and procedure, and attitude matters more than people realize. Now, instead of speeding things up, the case gets pushed out to March 10th. That's months of delay over what was basically a breakdown in communication and courtroom control. And the moment the judge says mute her, that's not just anger, that's the court taking back authority. Once it happens, you're not arguing anymore, you're being managed.
We need a Mandarin interpreter.
That's one. Apologize. Would you like me to do that now, or want to do your something first?
I don't know what he wants from me.
Okay,